favorite. What is this style? No, that's that one.
All right, we're getting on here slowly but surely.
Let me go check my desk.
Do what?
You're around Sarah this week?
The odds are the odds are Thursday or Friday at some point I was probably around her in the office.
I was on Thursday.
You know, because she can't stay away from Christine. It's like two magnets.
Or am I just tired?
It's,
Well, honestly, I woke up at 3.
I mean, I've got congestion, but I'm assuming it's just sinuses like I've had for the last month. They just won't go away. So. Bear with us while we try to figure out what happened to the jail.
Sure.
All right, please stand by. Apparently the jail's having technical issues.
Okay.
Same day results in her.
I'm sure she can get instant results, I suspect. You know, Mr. Rosenbach, a really public service oriented ADA right now would be entertaining all of us.
I'm still digesting my lunch. I don't want
It's,
to.
it's 1:40. You're still eating your lunch?
No, I'm digesting.
Oh, okay. Never mind.
I have a really big water bottle.
How about some jokes? Any jokes for us, Ben? No.
Is the law library on?
It's Courtney's the first one.
Well, what if we throw Jonathan up there and, well, we can't take care of Cooper because we don't have the, we have the new documents.
Yes, I have. He had them, so I do have them. You want to take care of her?
Yeah, because we're stuck. We can't get to the jail.
Okay.
All right, as far as I know, we just have one out of custody person, so we're gonna knock that out while we're waiting. It should be page 3, very last one. Ready, Paul? Court will call, just hang on the phone. Court will call cause number CR 11-99, the state of Texas versus Alyssa Cooper. For purposes of an agreed plea, what say the parties?
State's ready.
Defense is ready.
Well, unfortunately, we're not ready. We don't have a waiver of the telecommunications plea that I can find.
I guess that's right, Judge. I can get one from the clerk if the clerk has one and get it filed.
We have a blank one by any chance?
I'd have to go check my emails to see if I have a blank one that they sent.
There's some in the tower.
She's not. I don't see how we're gonna get this done. We're gonna have to move it to Friday. Because even with the form, we don't have any way to get the signatures.
Okay, Judge, and I guess, and of course you mean Ms. Cooper's signature too.
Right. So can we shift this to Friday morning?
Sure. And I'll have Ms. Cooper zoom back in and we'll get that done by then.
Is Ms. Cooper local or out of state or?
No, she's a New Mexico judge.
Okay. Yeah, working with the DA's office, but we'll need to get the signatures before we can proceed.
Sure. All right. Sorry about that, Judge. Thank you.
No problem. Thank you. Thank you, Ms. Cooper.
Thank you.
Did I give him a blank form?
I would. It's pretty unproductive.
Excuse me, sorry about that.
Judge, I just talked to the jail and I gave them the number and they're trying to log in now. I can't hear you. You're on mute. There
What
you
were
go.
they doing before?
I'm not real sure. I don't know that they had the right Zoom number possibly, but I'm not real sure. The jailer just called and said that she was trying to get logged in now.
Okay, thank you.
Uh-huh.
I mentioned how much I dislike them. It's a different ID number than what they've ever had before.
Mhm.
Holy cow. Can you hear me in the jail?
Oh, okay.
Okay, can you hear me?
There we go.
Okay.
Are you Miss Waterman?
Yes, sir.
Can I see the two files, please? Thank you. Paula, you ready? Okay. Court will call cause number CR 2141 and 21175. The state of Texas versus Don Waterman for purposes of arraignment. What say the parties?
State's ready.
Defense is ready, Your Honor.
Have you had an opportunity to go through both indictments with your client?
I did, Your Honor.
Are the personal identifiers true and correct to the best of your knowledge?
To the best of my knowledge, they are, Your Honor.
Does she desire to have either indictment read in open court?
We will waive the reading of the indictment, Your Honor, and she is entering a plea of not guilty on both.
Thank you. Ms. Waterman, the court will enter scheduling orders in both your cases. In each of your cases, your next scheduled appearance before the court is December 6th. If you're out on bond, it's at 8:30 in the morning. And if you're not, we'll see you in the afternoon, okay?
And Your Honor, if I may I ask I'm asking if we could entertain a oral motion for a PR bond right now?
No, ma'am. You got to follow the order and then we'll go
Okay,
from
thank
there.
you, Your Honor.
You're welcome.
Is that it?
Next person up will be Kevin.
Gotcha.
Thank you. Sure. How are you, Mr. Kevin?
Actually, I'm doing just fine. How you doing, sir?
Doing well, thank you. Court will call cause number CR 21-158, the state of Texas versus Eric Cavan for purposes of arraignment. What say the parties?
State's ready.
Defense is ready.
Have you had an opportunity to go through the indictment with your client?
Yes, Your Honor.
Personal identifier is true and correct to the best of your knowledge?
To the best of my knowledge, they are, Your Honor.
Does Mr. Cavan desire to have the indictment read in open court?
We are waiving the reading of the indictment, Your Honor, and he is entering a plea of not guilty.
Thank you. Mr. Cavan, the court will enter a scheduling order. Your next scheduled appearance for the court will be December 6th. If you're out on bond, it's at 8:30 in the morning. If you're not, we'll see you in the afternoon. Thank you, sir.
Oh, yes, sir. Yes, sir. I'm sorry. What about the bond? I'm sorry. If you're out on bond. Okay, so I get my bond back?
That's between you and your bonding company.
Last time that we met, the only reason I'm in here, sir, is because I admitted to
Oh, that's right. You were positive.
I admitted to positive. I didn't take your analysis, but
You need to talk to your attorney and then you can go from there, okay?
We'll talk more about that later this week, Eric.
Thank you, sir.
Okay. Thank you, sir. You have a good day, Mr. Emerson.
Thank you.
Yes, sir.
Saldana. Just now popped in. Good afternoon, ma'am. Court will call cause number CR 21-113 and 114, the state of Texas versus Juliana Reyes for purposes of arraignment. What say the parties?
State's ready.
Governor Humberto Saldana for Juliana Reyes. Believe I have a motion to withdraw on file. Wanted to see if we could take that up.
Do we need to take that up before we arraign her or afterwards?
Judge, whatever your call is, I mean, I guess we could do arraignment and then take it up.
Have you had an opportunity to go through the indictments with your client?
I have not, Your Honor.
I'm sorry.
I have not.
All right, then let's take up the motion of withdrawal since we can't address the arraignment. Go ahead.
Judge, Juliana Reyes had entered into an agreement to get me a certain sum of money. She's failed to do so. She had failed to keep contact with me, and she was apprehended some 3 or 4 weeks after last contact. For those reasons, and because I feel it would be hard to maintain contact with her, and also because I'm far into my tenure working as an assistant district attorney for Medina County, I'm asking for a withdrawal at this time. I believe Ms. Reyes, if I'm correct, was seeking court-appointed counsel. I don't know if she could verify that or not.
Ms. Reyes, do you have a position on Mr. Saldana withdrawing?
No, if he wants to withdraw, that's fine. I did try to seek court appointed counsel, but I was denied since he had yet to step down.
Okay, Mr. Saldana, I'm going to go ahead and grant your motion to withdraw in both cases. Ms. Reyes, I have, looks like an application for court-appointed counsel that was submitted on September 17th. Does that sound right?
Yes,
And are you still employed?
no,
Is all the other information still correct?
no,
What's changed?
everything. I have nothing.
Okay, then wait, let me just stop you then. Why don't you fill out a new application and submit it? If you can get it filled out today, they'll give it to me tomorrow. And then I can look at it. And if you qualify, I can get you a court-appointed counsel appointed. Okay.
Yes, Your Honor.
Okay. And in the meantime, what we'll do is set you for November 15th for arraignment on both of these cases. If you get out on bond, it's at 8:30 in the morning.
Do I have a bond, sir?
Yes, ma'am. Looks like you do.
Can I get a bond reduction?
Not right now.
Thank
Fill
you.
out your application for court-appointed counsel and then we'll take a look at it. Okay.
Thank you.
Thank you. Is that us or Mr. Sultana?
Yeah, that's Umberto.
Okay,
I think he's asking if he can be excused.
you may. There. Let me sign his other order.
Okay.
Court will call cause number CR 21-131, State of Texas versus Luke Williams. For purposes of arraignment, what say the parties?
State's ready.
And defense is not ready, Judge. I have not had a chance to go out and go over the indictment with him, but I'd like to do that tomorrow or Wednesday and file a waiver once we do that.
All right, very well. Let's do that and we'll put you on the next court docket, Mr. Williams. And if you're out on bond, it's at 8:30 in the morning.
Yes, sir.
Thank you, sir.
Thank you.
Mhm.
Hello,
Hi. Can you give me your name, please?
Abigail Reeves.
Hang on real quick while we find your files. Court will call cause number CR 20-177 and 178. State of Texas versus Abigail Reeves for purposes of the 2801. What say the parties?
State's ready.
Defense is ready, Your Honor.
Do we have any announcements or motions?
None from the state.
None at this time, Your Honor.
All right, it looks like our next scheduled pretrial is November 15th. If you're out on bond, we'll see you at 8:30 in the morning. If you're not, we'll see you in the afternoon. Thank you, ma'am.
I do have a quick question, Your Honor. I believe the state filed a motion to revoke her bonds, and I was wondering if that motion was granted.
I don't know. Hang on just a minute and I'll look and see.
Okay, thank you.
Sure. It was on October 1st.
Okay, thank you, Your Honor. And what was the court date again? I'm sorry.
I'm sorry,
What was the court date that you assigned her?
November 15th.
Thank you, Your Honor.
You're welcome. Thank you.
Do I have can I ask a question? Do I have a bond?
Talk to your attorney, ma'am.
Okay.
Chief, are you done with her?
Looks like Jesus Hawkins is next.
Okay.
All right, thank you.
I don't know. Court will call cause number CR 21-179, the state of Texas versus Jesus Hawkins III for purposes of pretrial. What say the parties?
State's ready.
Defense is ready, Judge, and just so Mr. Hawkins understands what's going on, I'm appearing for Mr. Danford today.
Do we have any pretrial issues from either side?
None from the state at this time.
None from the defense, Judge.
All right, Mr. Hawkins, we will see you back on November 15th. Thank you, sir.
Thank you.
Yeah, Rick. Yeah, there he is.
I'm here, Judge.
Saw that. Did you have a good weekend?
Yes, sir. How are you? How was yours?
It was good. Thank you. Lots of rain. Made
Yeah,
everybody happy.
yeah.
Yeah. You ready? Court will call cause number CR 18-179, the state of Texas versus Kevin Frankie. For purposes of motions to proceed, what say the parties?
We're ready, Your Honor.
Judge, let me, on Mr. Frankie,
State,
I don't
Mr.
believe it's-
Harpo,
yes,
he's going to accept your offer. If it's still on the table, I've got to go to the jail and get him signed up.
okay, well, that's why I was just pausing, because I thought we had worked it out where we did need to announce on the motion to proceed.
Okay, I'm sorry. Yeah, the deal that you and I talked about, he's going to take that.
Okay. Well, then, Judge, I would just, if it's okay with Mr. Ellison, ask that it be reset for a plea this Friday at 8 a.m.
That works.
All right, Mr. Frankie, we'll see you back on Zoom at 8 a.m. Friday. Thank you.
All right, my excuse, Your Honor.
You are. Thank you.
You're welcome.
It's gonna be busy. And that's just with Basndera cases, not counting her. Court will call cause number CR 21-149, 150, 151, and 152. The state of Texas versus Gilbert carry on. For purposes of pretrial, what say the parties?
State's ready?
The defense is ready, Your Honor.
Do we have any pretrial issues?
None from the state.
Well, Your Honor, I've been advised that Mr. Carry-On has retained private counsel. I believe it's been Roy Barrera. Is that correct, Gilbert?
I believe so.
Or your family has? That's what I was told, but I've not seen anything. So as far as an order or motion to substitute.
Court hasn't seen anything either. So what we'll do is set the next pretrial for November 15th, and that'll give Mr. Barrera time to follow his motions.
Okay, will do.
Sir.
All right, we'll see you back next month. Thank you.
Thank you.
Court will call cause number CR 21-143, the state of Texas versus Michael Mitchum. For purposes of a 2801, what say the parties?
State's ready.
Mr. Black, you're muted.
I'm sorry, Judge, that's too many
There
of
we
us
go.
using one computer. Defense is ready, Judge, except to the extent that I would, if it's possible, I'd like to reset the case for another 2801 hearing, just because of my schedule.
Any objections?
No objection.
All right, the 2801 will be reset for November 15th. We'll see everybody back then. Thank you.
Thank you.
Court will call cause number CR 21-137, 138, and 162. State of Texas versus Nathan Silva for purposes of a 2801. What say the parties?
State's ready.
Defense is ready, Judge. We have also a motion to reduce bond that we'd like to take up if possible.
We'll do that in just a moment. Do we have any announcements or other motions related to the 2801?
None from the state.
Not from the defense, Judge.
All right. Mr. Black, you're up.
Judge, on his charges, the obstruction and retaliation charges, he has 3 counts. The bond in that case is set at $100,000 surety bond. Then he's charged with escape, which is set at a $20,000 surety, and then an assault, family violence, impeding breath, a $15,000 surety. Judge, we believe those amounts are excessive. My client's indigent, Your Honor, and he lives in the community. And I'd like to put him on and ask him a few questions about the bond.
You may. Mr. Silva, please raise your right hand. In the matter before the court, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, so Nathan, would you tell the court where do you live?
I live in Pipe Creek.
And how long have you lived in Pipe Creek?
32 years.
Okay, and do you have family here?
Yes, sir.
What part of your family lives here in Basndera?
My mother and 2 of my brothers.
Okay. And are you married?
No, sir.
Do you have any children?
Yes, I have 3 children.
And do you work to support those children?
Yes, I do.
All right, and where do you work?
I just do handyman service.
Okay. Now, we talked about the amount of bond that you possibly could make, Nathan. Is $10,000 an amount in a surety bond that you think maybe you and your family could be able to raise enough money to post?
Yeah, I think that would be possible.
Now, you don't have anywhere else to go, do you?
No, sir.
So if the judge were to let you out on bond, you wouldn't leave this area, would you?
No, sir.
And would you show up for every court date?
Yes, sir.
I'll pass the witness, Judge.
Cross-examination?
You may.
Thank you. Mr. Silva, where do you live? Like, I understand that you're in jail, but if you weren't in jail, where would you be living?
In Pipe Creek?
No, but like this incident that you're in jail for involves breaking into your mother's home. At that time, where were you living?
I live on the same property.
Okay, that's what I'm trying. That's my understanding as well, that your mother's home that is the subject of this offense is the same property where you live, correct?
Yes, sir. But that's not where I'll be living whenever I get out.
Okay, so where would you be living if you get out?
With my girlfriend.
And in relations to where your mother's property and where you were living, where is your girlfriend's place?
She also lives in Pipe Creek, but a different property though.
Is it near your mother's residence?
It's about 5-6 miles away.
Okay. Now I'm taking it that your girlfriend is not the mother of your children.
No, sir.
Okay. All right. Now, as far as tell me about your mental health issues. What do you have? Are you taking any kind of medications for mental health?
No, sir.
have you ever been referred to MHMR or, MMMR for mental health evaluation?
No, sir.
Okay. I don't want to get into the evidence to any of the, like discussing necessarily the facts of the incident that occurred, but well, I can talk to the court about that. All right. So on the night of, okay, so here's what I'm just trying to get at. During this incident, and I don't want you to talk about like the facts, but were you, was there any mental health medication that you were supposed to be taking but weren't taking the night of the incident?
No, sir.
Okay. Now, as far as your criminal history, have you ever been arrested or charged with a felony?
No, sir.
Okay. Now, when you talked about having a handyman job, is that something that you just work out of your truck or your vehicle?
Yes, sir.
What kind of vehicle do you have?
Ford Explorer.
Okay. Are you ever required as a part of your job to have to travel out of the county or anything like that?
Not usually.
Okay. I have no other questions, Your Honor.
No questions. No further questions.
Additional witnesses?
No,
None from the state.
none from the defense.
Court's going to deny the motion to reduce bond. We will see everybody back on November 15th for a pretrial.
Thank you.
Hey, Mr. Fanning.
Oh.
Court will call cause number CR 1716 and 1717, State of Texas versus James Fanning for purposes of pretrial. What say the parties?
State's ready.
Defense is ready.
Do we have any pretrial issues?
None from the state.
None from the defense, Judge, other than to say we did receive the competency evaluation back, and Dr. Wood did find him to be competent.
All right, let's set it for, let's set another pretrial on November 15th, and then we'll set the 2801 in December. So we'll see everybody back on November 15th.
Thank you.
Thank you, sir.
Afternoon. Court will call cause number CR 20-154, 179, 203, CR 2190 and 91, the state of Texas versus Christopher Raina. For purposes of pretrial, let's say the parties.
State's ready.
This is ready.
We have any pretrial issues to address?
None from the state.
None from the defense at this time, Judge.
All right, it looks like our next scheduled appearance before the court is November 15th for a 2801 hearing. So we'll see everybody back then. Thank you.
Thank you.
Should have said, not Andrew or Elijah. Hopefully, I had already told them on Friday not to bring those two.
Okay, well, hopefully they don't.
Yeah,
So Brandy Thornton should be next.
correct.
Okay. How are you, Miss Thornton?
Okay.
Okay, give me just a minute to play catch up. Court will call cause number CR 2170, 71, 72, 73, 132, 133, and 134. State of Texas versus Brandy Thornton. For purposes of pretrial, what say the parties?
State's ready.
And defense is ready.
Do we have any pretrial issues?
None from the state.
At this time, we do not, Your Honor.
I would also just add, Judge, that all the labs are in, so we're good on that front.
That was my next question.
Yes, sir. I just saw that the last of the labs came in recently.
All right. Let's schedule a 2801 for November 15th, and then we'll go from there.
Sounds good. Thank you, sir.
When are you gonna come and see me?
Tomorrow.
Okay, that's what you said in August.
I'll be there tomorrow. I've got 3 people to see tomorrow.
Okay,
Thank you, Ms. Thornton.
thank you, Mr. Emerson. That's ridiculous.
Thank you. Court will call cause number CR 21-109, the state of Texas versus Johnny Urania. For purposes of a 2801 hearing, what say the parties?
State's ready.
Defense is ready.
We have any announcements or motions, council?
None from the state.
Oh, none from defense at this time.
All right, Mr. Urania, it looks like your next scheduled appearance before the court will be November 15th. So we will see you back then. Thank you, sir. What's he doing?
Oh, no. I don't think he wanted to see Dave. That was my take.
Hey, not very many people want to see me right now.
You don't have colorful hair like you usually do.
Yeah.
No, it's growing out a little bit. So, although it is Monday, so I got my Mickey Mouse tie on. Hey, Steven.
Sir.
Hey, on this next case, I have no announcement for pretrial.
Yes, sir.
Do we really want to bring him out to do this?
We don't need to.
No, I don't think so either, Judge.
Can you hear us in the jail? I don't think there's anybody in the room in the jail.
Missed opportunity.
Monica, do you want to call and tell them they don't have to bring out Mr. Roach if they don't want to? Just call him right here if you'd like.
Judge, I'll make that call.
Okay, thank you, Tammy. We'll pass him till November 15th.
Sounds great. Thank you.
Sounds good. Hopefully we get something worked out by then.
That would be wonderful.
Is the next one Deering?
The next one is Gibbs.
Gibbs?
Not to be confused with the BG. Yeah, I'm dating myself, I know.
Yeah.
I do think it was a bad strategic error on their part. My understanding is that's the same time that the Austin City Music Festival is going too. Because I know the turnout was pretty light. Yeah. Ready? Court will call cause number CR 21-144, State of Texas versus Bradley Gibbs. For purposes of pretrial, what say the parties?
State's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
None from the state.
No, Your Honor.
All right, it looks like our next scheduled appearance is November 15th for a 2801 hearing. So we'll see everybody back then.
Thank you, Judge.
Thanks, Mr. Gibbs.
Thank you.
Thank you. Did Deering come back competent? You remember?
Yes, Your Honor, she did.
Okay, thank you.
Mhm.
Do I need to write it on here?
All right, the court will call cause number CR 21-142, State of Texas versus Amanda Deering for purposes of pretrial. Would say the parties.
State's ready.
Defense is ready.
We have any pretrial issues, counsel?
None from the state.
None at this time, Your Honor.
Our next scheduled appearance is November 15th, and we'll have a pretrial. Ms. Deering, if you're out on bond, it'll be at 8:30 in the morning. If you're not, we'll see you in the afternoon. Thank you, ma'am.
Yes.
November 15th.
And Your Honor, not to skip ahead, but on Mary Catherine Stewart, since she was found incompetent, I don't believe that the jail will need to bring her out.
Can you hear that in the jail? You have to call them again. Apparently they're running one person. They just won't.
Is she next?
No, but she'll be coming up. She's like 3 down, number 3 down.
Mary Catherine Stewart, we do not need her in court.
Thank you, Your Honor.
All right.
You're
thank you.
welcome.
Bye-bye.
Just like her ancestor.
This is Mr. Patterson. Yeah. Set for trial tomorrow.
We have a second one.
We don't have a backup right now.
This was yours, Ben.
Hi, Mr. Patterson.
Hello there.
Court will call cause number CR 21-7, the State of Texas versus Pete Madison for purposes of pretrial. What say the parties?
State's ready, Your Honor.
Your Honor, defense is not ready at this time. If you haven't received it already, this case is getting switched over from Anthony Welch to myself, and I'll be requesting one more pretrial setting, please.
We don't have any objection to that, Your Honor.
All right, let's set a pretrial on November 15th and trial on November 16th. So we'll see you next month.
Thank you,
Thank
Your
you,
Honor.
Mr. Patterson.
Thank you, sir.
Ben, was he the guy driving the lawnmower or the
Harley.
Harley? Okay.
Muted. Court will call cause number CR 2138 and 21172, State of Texas versus Cody Wisecarver for purposes of pretrial. Let's say the parties.
Judge, the state's ready, but I was just seeing that has a mental evaluation still pending where I don't think we have a report yet.
The defense ready, Your Honor, and that is correct. I did speak with the doctor. She has already met with my client and she intends on getting us the report by next week.
Just out of curiosity, when did you meet with your client?
She met with him on the 20th of September, and she said that the report should be here by no later than, I believe she said the 11th. That was an email that I got from her today.
Okay. All right. We're going to reset for pretrial on November 15th. And hopefully we'll have a better idea where we stand by then.
November 15th. Yes, Your Honor. You got it. Thank you very much.
Yep. Court will call cause number CR 19-246, the State of Texas versus Kevin Shannon. For purposes of pretrial, let's say the parties.
State's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
None from the state.
None at this time, Your Honor.
Do we need one more pretrial before we jump on the trial docket, or are you ready to get a trial date?
One more pretrial would be appreciated, Your Honor.
And I would just, for the court's information, the labs are in. We do have the labs.
Thank you. All right, we will set one more pretrial on November 15th, and then at that point, we'll set a trial date. Thank you all.
Thank you, Your Honor. Your Honor, did you still want an update on Mary Catherine Stewart?
Sorry?
Did you still want an update on Mary Catherine Stewart, even though we aren't going to call her out?
There's really nothing I can do. As long as you and Mr. Harpold are staying in touch, then we're good.
Okay, great. Thank you, Your Honor.
Sure. go. Court will call cause number CR 21-55, the state of Texas versus Gladys White. For purposes of pretrial, let's say the parties.
It's ready.
Defense is ready.
Do we have any pretrial issues, counsel?
None from the state.
Your Honor, would you entertain a oral motion for a PR bond this afternoon?
Mr. Harple?
I don't mind, Judge, if you can just bear with me to pull up the case for just like 30 seconds, and then I'll be ready. I'm ready, Your Honor.
Okay. Ball's in your court, Ms. Daly.
Thank you, Your Honor. The defense is asking that Miss White be released on a PR bond. She is currently in custody because back on September 13th, she had a court date that she appeared for at 10:45, 15 minutes after the court recessed. And she was given an FTA and placed in custody. She was late that day because she takes a medication called Kryquil. I hope I'm saying that right. And that medication is to help her sleeping. And she was working until 2 a.m. the night before. She does pedicab work in Austin. And so she took her medication later than she usually does. And her medication basically just kind of knocked her out. She didn't wake up for alarms, but she did try to get to court as soon as she could. Additionally, she has 2 young boys in her household, 8 and 11, that she does help provide for. And for the past couple of weeks with her being in custody, they've had to make some sacrifices as far as like the kids' extracurricular activities and things like that, because they don't have the income that Miss White was bringing in. Also, you know, they didn't have the extra hands on deck to get them to their extracurriculars. And Ms. White is indigent, so even a bond reduction would likely be unhelpful for her because since she is self-employed and does the pedicab and also does cleaning on the side, she hasn't been able to work for the past few weeks, so she's unable to come up with a bond amount. So that is why we're asking for a PR bond, Your Honor. In the alternative, we are asking that the bond be reduced to at the most $500, Your Honor.
You want to call your client or you just argument?
Just argument, Your Honor.
Mr. Harple?
Judge, I would just point out to the court that based upon the offense report, this case arose out of an alleged suicide attempt, which involved allegedly intoxication on the part of the defendant with mental disorder issues. I don't recall just sitting here the conditions of why she's in custody, but I just wanted the court to be aware of that.
May I respond, Your Honor?
You may.
Since the incident, Ms. White has been going to an outpatient treatment program in Austin, and she's been unable to finish that program because she was arrested for being late in court. So she is taking steps to get treatment and get better, but she's unable to complete those steps because she's in custody.
How long has your client been working? In other words, how long she's been on this job?
Which one, the pedicab or the maid?
Whatever she's doing right now to earn an income.
Right now, I believe it's mostly the pedicab, and I'll let Ms. White answer that, how long she's been doing that.
I've been working as a house cleaner for Home Glow since I do believe it was April of this year. So I can set my own schedule. And then the pedicab is it's more of a seasonal thing. I have it's basically contract work whenever they have private events in Austin.
How much do you earn as a house cleaner?
Initial clients, it's $25 an hour. Afterwards, it's $30 an hour.
And how often do you actually get to work as a pedicab driver?
That was my first job back on for this season. I had 3 others that I missed because I was incarcerated.
Okay. Reason I'm asking is because none of this is on your application for court-appointed counsel.
I don't know why.
So, well, me either, since you filled it out, but I need to fill in the blanks.
Okay.
And how many hours a month do you typically work as a housekeeper?
A month?
Yes, ma'am. Or a week, for that matter.
A week. I'd say roundabout 20, less than up to 20 hours a week. I can I have my pay stubs on my or I have record of my pay stubs or was it my 1099? I think that's what it is. On my on the website. I can get it printed out.
Kind of between a rock and a hard spot in this, Daily, because if your client would have put that information on the application for court-appointed counsel, she would not have qualified. So essentially, she has court-appointed counsel without qualifying for it. Are the 2 boys that are at the house, are they your clients or do they belong to her housemaid or?
They're her fiance's boys, but they've been in her care as well. And she does help, and her salary is used to take care of them as well.
And does her fiance work?
He does work, yes.
Does the state have a position on the bond one way or another?
No, Judge, I was more concerned with her well-being and her protection and the people that she was with when this incident occurred. As far as, to me, it sounds like she's living in Austin now and is not in this community.
No, sir.
She's just working in Austin, Your Honor, and she's commuting.
Oh, I see. I'm sorry about that. So I would just defer to the court's discretion.
The court's going to reinstate the bond that was on the indictment. And Ms. White, the court's going to order you to fill out a new application for court-appointed counsel. And please be sure this one's accurate.
Yes, sir.
All right, we'll see everybody back on November 15th for a 2801 hearing. If you're out on bond, it's at 8:30 in the morning.
Yes, sir.
Thank
Thank you,
you.
Your Honor.
Is that it?
Is this Mr. Smith or Mr. Schindler?
Mr. Smith?
Mr. Blackie, you represent Mr. Smith or is it Mr. Parent?
I am, Your Honor.
Okay. Court will call cause number CR 18-215, the state of Texas versus Martin Smith for purposes of a motion to revoke. What say the parties?
Judge, ready, and I believe we're entering a plea for today.
That is correct, Your Honor.
Paperwork. We have no documents at all.
And Judge, the paperwork was brought to the jail. I went over there and had my client sign those papers at the jail. They were supposed to forward those papers to the district clerk after those were signed.
When did you do that?
Oh, about a week and a half ago.
You know, I hadn't received anything. All right, let's pass Mr. Smith for right now and see if we can find the paperwork.
Okay, you want me to stand by here online for a little bit?
Please. And Mr. Smith, if you'll bear with us, we'll bring you back out shortly. Let's see if we can find your documents, okay?
Yes, sir.
Thank you. Yep. Let me give these back to you so I'm not tripping over the files. Thank you. Mr. Schindler, is that correct? Thank you. Court will call cause number CR 2152, 53, and 54. The state of Texas versus Scott Schindler for purposes of an agreed plea. What say the parties?
State's ready.
Defense is ready.
First document we need to go through on each of these cases is a joint request for plea or sentencing by video conference. It purports to be signed by all parties. Mr. Schindler, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. The next document we need to go through in each case is the 3914 Discovery Disclosure and Compliance Form, which purports to be signed by each of you, counsel. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
To the best of your knowledge, on all three of these cases, has the state received all their discovery from law enforcement and forwarded the same to the defense?
Yes, sir.
To the best of your knowledge, have you received all the discovery in all three cases?
Yes, sir.
Any objection to going through the admonishments together?
No, sir.
No, sir.
Mr. Schindler, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments.
I seen a yes. I signed it.
There's one in each case. Did you have a chance to go through all three of those documents with your attorney?
Yes, sir.
Did you understand all three of those documents?
Yes, sir.
Do you understand in all three cases you have a right to a trial by jury?
Yes, sir.
Do you understand in all three cases you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes,
And do you understand in all three cases you have a right to appeal?
yes, sir.
Do you understand that you're waiving all three of those rights in all three cases today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right. You understand that?
Yes, sir.
Yeah, I have to ask you for an oral answer because it's hard for the court reporter to take down a head nod, okay?
Just you're quiet on it. I'm sorry, I was joking.
Page 3 of each of these documents purports to have your signature in 2 locations.
Yes, sir. Yes, sir.
Is that your signature in both spots?
Yes, sir.
Your second signature on each one appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that document, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing in each of these 3 cases?
Yes, sir.
Attached to the back of each one of these is the grand jury indictment that goes with that case. Each one of these indictments purports to have your signature. Do you recall signing all 3 of those indictments?
Yes, sir.
And are you asking the court to accept as true and correct all 3 of those grand jury indictments?
Yes, sir.
Do you feel like your client understands his rights, waivers, and admonishments in all 3 cases?
Yes, sir, I do.
In cause number CR 21-52, there's a document entitled Agreed Stipulation of Evidence and Waiver of Testing. Did you have a chance to go through this document with your attorney?
Yes, sir.
Did you understand this document?
Yes, sir.
And is that your signature on here?
Yes, sir.
You understand that by signing this document, you're stipulating that the evidence is what the state says it is, and you're waiving your right to have it tested.
Yes, sir.
Mr. Blake, do you feel like your client understands his agreed stipulation and waiver?
Yes, sir, I do.
Cause number CR 21-52, you've been charged with possession of a controlled substance, to wit methamphetamine less than 1 gram enhanced. As enhanced, this is a 3rd-degree felony that's being enhanced to habitual 25 years to life. Do you understand that charge and that range of punishment?
Yes, sir.
And how do you plead? CR 21-53, you've been charged with forgery of a government document. Looks like to wit U.S. currency enhanced. As enhanced, this is a 2nd-degree felony enhanced to habitual, that being 25 years to life. Do you understand this charge and this range of punishment?
Yes.
And how do you plead?
Guilty.
CR 21-54, you've been charged with burglary of a building enhanced. This is a 3rd-degree felony enhanced to that of habitual 25 years to life. Do you understand this charge and this range of punishment?
Yes.
And how do you plead?
Guilty.
On all 3 of these cases, there are 2 enhancement paragraphs. Do you recall going through those with Mr. Black?
Yes, sir.
And do you plead true or not true to the 2 enhancement paragraphs?
True.
Are there plea agreements?
Yes, Your Honor. 10 years deferred adjudication. Drug and alcohol treatment approved by the probation department. No early termination. Completion of the LTIP. And in all three cases, there's a $1,500 fine.
Is that your understanding, Mr. Black?
Yes, sir, it is.
Mr. Schindler, I got ahead of myself just a little bit, so I want to clarify something. On all three of these cases, are you pleading guilty freely and voluntarily?
Yes, sir.
On all three of these cases, are you pleading guilty because you are guilty?
Yes, sir.
And is that your understanding of the plea agreement in all three of these cases?
Yes, sir.
Let's talk about deferred adjudication, please. Do you understand that deferred adjudication is like a two-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. Do you understand that?
Yes, sir.
Okay, do you understand the flip side of all three of these cases? And this is extremely important because of the nature of your offenses and the enhancements in all three of these cases. If you violate your terms and conditions of probation, do you understand you're subject to the full range of punishment, which is up to life?
Yes, sir.
Do you also understand that a plea agreement's an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow your plea agreement?
Please.
Mr. Black, do you feel like your client's competent and capable of assisting you in preparation for trial in all three cases?
Yes, sir, I do.
CR 2152, CR 2153, and CR 2154. Court will find evidence beyond a reasonable doubt in all three cases. In all three cases, will defer any such finding of guilt for a period of 10 years. You have a $1,500 fine in each one. If ordered by probation, you must successfully complete a drug and alcohol treatment program. There's no early termination of probation, and you must successfully complete the Life Training Institute program. In addition to that, you have court costs in the amount of $290 in each one. And in CR 2152, you have reimbursement fees in the amount of $1,237.50. In CR 2153, you have reimbursement fees in the amount of $740. And in CR 2154, you have reimbursement fees in the amount of $580. Do you have any questions on any of these three judgments?
No, sir.
And just to make clear, they're all going to run concurrent, so they're all running at the same time, okay?
Yes, sir.
Once you get released, can you work out a payment plan to pay off your cost?
Yes, sir.
Attached to the back of all three of these judgments is an order granting community supervision.
Yes, sir.
Did you have a chance to go through those orders with your attorney?
Yes, I did.
Did you understand those orders?
Yes, sir.
Do you understand those orders contain all the terms and conditions of probation?
Yes, sir.
Do you understand your terms and conditions of probation include a $60 per month probation fee? There's three cases, but there's only one fee, okay?
Yes, sir.
You understand that all three of the cases carry a $50 Crime Stoppers fee that's due within 6 months?
Yes, sir.
You understand you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
Do you understand you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the Life Training Institute program?
Yes, sir.
And do you understand that if ordered by probation, you must successfully complete a drug and alcohol treatment program?
Yes, sir.
Where do you work?
I don't work right now, but I work in Basndera County.
Okay, what type of work did you do?
Construction, I'm an electrician.
You should be busy, I would think, if you're an electrician.
Yeah, so, yeah. Yeah. Yes, sir.
I'm gonna put all your community service in one case, so it's easier for you to keep up with. In CR 2154, there'll be 300 hours of community service. Work with your probation officer so they can work around your job.
Sir, I am very active in my church. Can I, instead of giving those hours to the church, can I take those hours off my probation?
You'll have to talk to your probation officer about that because it depends on a number of factors as to whether they'll qualify for that or not. Okay. Some nonprofits qualify, some don't.
Yes, sir.
You have any other questions?
No, sir.
Good luck to you, Mr. Schindler. Thank you.
Mr. Schindler,
Yes.
I'm with the probation office. As soon as you get released, will you come over to the office, please?
Yes, sir.
Thank you.
Well, do I have a hold on me from Wilson County?
I don't know about any holds that you have.
Okay, thank you.
Okay, just while we have everybody on here, for Mr. Martin Smith, there is not any paperwork that was located in the jail. So y'all are gonna have to either figure out whose file it's stuck in or redo it. We can do it as early as Friday if we need to.
All right, Stephen, you want to send it to me again? And I'm going to go over there tomorrow to see a bunch of clients anyway. I can go ahead and have him fill it out again.
We'll do it.
I appreciate it.
Thank you, Dave.
Thank you. That's all I have. May be excused.
You may. Thank you.
Thank you, sir.
Kimberly Hill will be next, but we're going to take a quick 5-minute break before we start that.
Sounds great.
Judge, may I be excused?
You may. Thank you, David.
Thank you, Judge.
Hi, Kimberly.
Can you hear me? Oh, can you
Yes,
hear
we can hear you.
Court will call cause number CR 213233 and then CR 21190. The State of Texas versus Kimberly Hill. For purposes of an agreed plea, what say the parties?
State's ready.
Defense is ready, Your Honor.
First document we need to go through in each case, counsel, is the 3914 Discovery Disclosure and Compliance Form, each of which purports to have each of your signatures. Is that correct?
Yes, sir.
Yes.
To the best of your knowledge, has the state received all discovery from law enforcement in all three cases and forwarded the same to the defense?
Yes, sir.
Yes, Your Honor.
Before we get to the admonishments, let's talk about CR 21190. This is a pre-indictment case. Ms. Hill, I'm showing you a document entitled Waiver of Indictment.
Yes, sir.
Did you have a chance to go through that document with your attorney?
Yes, sir.
Did you understand that document?
Yes.
Do you understand that normally you have the right for your case to be presented to the grand jury and the grand jury to determine if there's enough probable cause for your case to proceed? But in this case, you're waiving that right on this particular case. Do you understand that?
Yes, sir.
Do you feel like your client understands their waiver of indictment?
I do, Your Honor.
Any objection to going through the admonishments together?
No,
objections.
none from the state, Your Honor.
Ms. Hill, I'm showing you one document, but in fact, there's three. There's one in each case.
Yes.
Each of them is titled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through all three of those documents with your attorney?
Yes, sir, I did.
Did you understand all three of those documents?
Yes, sir.
Do you understand that in all three cases, you have a right to a trial by jury?
Yes, sir.
Do you understand that in all three cases, you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand that in all three cases, you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights in all three cases today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right. You understand that?
Yes, sir.
Page 3 of each of these documents purports to have your signature in two locations. Is that your signature in both spots?
Yes, sir.
Your second signature on each document appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph in all three documents, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of each of these documents in CR 2132 and 33 is a copy of the grand jury indictment. And then in CR 21190 is a copy of the complaint and information, which is the charging instrument pre-indictment, okay? But attached to the back of all three documents is a copy of the charging instrument that goes with that particular case. Did you have a chance to go through all three of those charging instruments with your attorney?
Yes.
Did you understand all three of those?
Yes, sir.
And are you asking the court to accept as true and correct all three of those?
Yeah, yes.
Two
Sir.
indictments and then one complaint and information. Do you understand?
Yes, sir.
Do you feel like your client understands her rights, waivers, and admonishments in all three cases?
I do, Your Honor.
Ms. Daly, when you finish up in there, do you mind coming by the courtroom? There's one signature spot that was missed, and we can get your signature on there, please.
Absolutely, Your Honor. I apologize.
Not a problem. Ms. Hill, in CR 2132, you've been charged with unauthorized use of a motor vehicle. Excuse me, this is a state jail felony with a range of punishment of 6 months to 2 years confinement and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And
Yes.
how do you plead?
Guilty.
CR 21-33, you've been charged with possession of a controlled substance, to wit 1 to 4 grams of methamphetamine. This is a 3rd-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
Cause number CR 21-190. You've been charged with possession of a controlled substance, to wit methamphetamine less than 1 gram. This is a state jail felony with a range of punishment of 6 months to 2 years confinement and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
On all 3 of these cases, are you pleading guilty freely and voluntarily?
Yes, sir.
On all 3 cases, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Are there plea agreements in all 3 cases?
Yes, Your Honor. In all 3 cases, the state is recommending 5 years deferred adjudication, drug and alcohol treatment approved by the probation department, completion of the LTIP, and then in cause number CR 21032, there's a fine of $1,500. And part of the agreement is also that cause number CR 21-153 will be dismissed.
Is that your understanding of all 3 plea agreements, Ms. Daly?
It is, Your Honor.
Ms. Hill, is that your understanding of all 3 plea agreements?
Yes, yes, sir.
Okay, let's talk about deferred adjudication. Do you understand that deferred adjudication is like a 2-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. Do you understand that?
Yes, sir.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment for the offense.
Yes, sir.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement in any one of these cases, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow all 3 plea agreements?
Please, yes, please.
In all 3 cases, cause number CR 2132, 33, and 190, the court will find evidence beyond a reasonable doubt to enter a finding of guilt. In all 3 cases, will defer any such finding of guilt for a period of 5 years. You must successfully complete a drug and alcohol treatment program if ordered to do so by probation. You must successfully complete the Life Training Institute program. All 3 cases have court costing the amount of $290. In CR 2132, you have a fine in the amount of $1,500 and reimbursement fees in the amount of $530. In CR 2133, you have reimbursement fees in the amount of $590. And in CR 21190, you have reimbursement fees in the amount of $455. All 3 cases will run concurrent with each other. Do you have any questions on any of these 3 judgments?
No, sir.
Once you get released, can you work out a payment plan to pay off your cost?
Yes, sir. I'm gonna get a job as soon as I get out.
What kind of work do you do?
I used to do property management. But I don't know if it shows up that I have the felonies, I might not be able to get a property management job, but I'll get a job, definitely.
Good, thank you.
Thank you so much.
Attached to the back of all three of these judgments is an order granting community supervision.
Okay.
Did you have a chance to go through those documents with your attorney?
Yes, sir.
Did you understand those documents?
Yes, sir.
Do you understand that all three of those documents contains all your terms and conditions of probation?
Yes, sir.
Do you understand your terms and conditions of probation include a $60 per month probation fee? There's
Yes,
three
sir.
cases, but there's only one fee. Okay. Do you understand that each of the three cases carries a one-time $50 Crime Stoppers fee that's due within 6 months?
Yes, sir.
Do you understand that you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
Do you understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the Life Training Institute program?
Yes, sir.
I'm going to put all your community service in one case so it's easier for you to track. In cause number CR 21190, you're going to have 200 hours of community service. So work with the probation officers so they can work around your job, okay?
Okay. Okay. Thank you so much.
Do you have any questions at all on your terms and conditions of probation?
No, sir.
Good luck to you, ma'am. Thank you, Ms.
so much. Thank you.
Ms. Hill,
Yes.
as soon as you get released, you need to come over to the probation office, okay?
Okay. Okay. Thank you.
Hi, Kimberly.
I
Good luck. Your Honor, do we need to come over there now and sign or wait till after Ms. Denman in case I missed a signature in that one too?
Wait till after Ms. Denman.
Okay, thank you.
Sure. Unless you're just wanting to get the steps in and you want to run over and run back.
I think I got plenty of steps in this morning, Your Honor.
Flag the two documents that need signatures. One of them needs it from the defense and one needs one from the state. So when they come over tomorrow, you're gonna have to get their signature. Denman. Keep. Okay, my understanding, the child abuse fine is, doesn't matter if it's deferred or conviction, correct? Yeah, it's the other one that requires a conviction. It's the last one. Good afternoon, Ms. Denman. Court will call cause number CR 21-125, the state of Texas versus Allison Denman. For purposes of an agreed plea, what say the parties?
State's ready.
Defense is ready, Your Honor.
First document we need to go through is the joint request for plea or sentencing by video conference. It appears to be signed by all the parties. Ms. Denman, do you have any objection to proceeding today by video conference?
No, I do not. No objection.
Thank you. The next document we need to go through is a 3914 discovery disclosure and compliance form, which purports to have each of your signatures, counsel. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
To the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, sir.
Ms. Daly, to the best of your knowledge, have you received all discovery?
Yes, Your Honor.
Ms. Denman, I'm going to show you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through that document with your attorney?
Yes, sir.
Did you understand that document?
Yes, I did.
Do you understand that you have a right to a trial by jury?
Yes, I do.
Do you understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir, I do.
And do you understand that you have a right to appeal?
Yes, I do.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of this document purports to have your signature in 2 locations.
Yes, sir.
Is that your signature in both spots?
Yes, it is.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of this document is a copy of the grand jury indictment. Did you have a chance to go through this indictment with your attorney?
Yes, sir.
Did you understand this indictment?
Yes, I did.
And are you asking the court to accept as true and correct this grand jury indictment?
Yes, sir.
Do you feel like your client understands her rights, waivers, and admonishments?
I do, Your Honor.
What's the correct spelling on your last name?
Denman.
Thank you. I'm correcting it on the judgment. Ms. Denman, you've been charged with abandoning or endangering a child without the intent to return. This is a 3rd-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, I do.
And how do you plead?
No contest.
That's not an option. You have to either plead guilty or not guilty.
Oh, my apologies. No, guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
You understand what I'm asking you? You had a little hesitation there. I want to make sure we're on the same page. Nobody's tricking you, threatening you, coercing you in any way to plea in this case, are they?
Oh, well, I understand that I went over the paperwork to sign over for 7 years deferred probation. So that's what I would be getting if I plead guilty, correct?
Correct. That's what's in your plea agreement.
Okay, I'm just double checking. Yes, sir. Sorry, I went to the dentist this morning and my mouth's in a lot of pain, so.
Sorry about that.
That's okay.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir, I am.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
I do, Your Honor.
Is there a plea agreement?
Yes, Your Honor. 7 years deferred adjudication, $1,500 fine, drug and alcohol treatment approved by the probation department, comply with the CPS guidelines, complete the life skills program, and no early termination of the probation.
Ms. Daly, is that your understanding of the plea agreement?
It is, Your Honor.
Ms. Denman, is that your understanding of the plea agreement?
Yes, sir, it is.
Okay, let's talk about the deferred adjudication. Do you understand deferred adjudication is like a two-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. Do you understand that?
Yes, sir, I do.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment for the offense.
Yes, sir, I understand.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, You would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial.
Yes, sir, I understand.
And are you asking the court to follow the plea agreement?
Yes, I am.
Court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 7 years. You have a fine in the amount of $1,500. You must successfully complete a drug and alcohol treatment program if ordered to do so by probation. Must follow the CPS guidelines. You must successfully complete a life skills class, and there's no early termination of probation. You have court costs in the amount of $290, and you have reimbursement fees in the amount of $590. Do you have any questions on the judgment itself?
No, I do not.
Once you get released, can you work out a payment plan to pay off your costs?
Yes, I can.
Attached to the back of the judgment is an order granting community supervision. Did you have a chance to go through that order with your attorney?
Yes, I did.
Did you understand that order?
Yes, I did.
You understand that order contains all your terms and conditions of probation?
Yes, I do, sir.
You understand your terms and conditions of probation include a $60 per month probation fee,
Yes, I do.
a one-time $50 Crime Stoppers fee that's due within 6 months?
Yes, sir.
Do you understand you're subject to random urinalysis and drug tests at your own expense?
Yes, sir.
You understand that you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation?
Yes, sir.
Do you understand you must successfully complete the life skills program?
Yes, sir, I do.
Do you understand that you must follow any CPS guidelines that are in place?
Yes, sir.
Where do you work?
I'm unemployed at this time, but I'm seeking employment as soon as I leave here.
What do you normally do?
I normally wait tables. I've been a server most of my life.
Think you'll have any issues trying to get a job?
I'm not concerned about it. As long as I'm persistent, I will get something really fast.
As a term and condition of probation, you're going to have 150 hours of community service. Work with your probation officer so they can work around whatever job you end up with. Do you have any questions at all?
I don't think so.
All right. Good luck to you, ma'am. Thank you.
Appreciate it.
Bye, Allison. Good luck.
Thank you. Appreciate it. Thank you for your help.
Of course.
Ms. Denman?
Yes.
Once you get released from the jail, you need to come over to the probation office, okay?
Okay, and that is here in Basndera?
Yeah, it's here connected with the jail.
Oh, okay. All right, no problem.
Thank you.
Thank you.
Your Honor, with the exception of my signature, may I be excused?
You may.
Thank
Thank you
you.
very much. Yeah. Mr. Harpolder, we cooked like a goose?
I was just flipping the pages and I think we're good to go.
Very good. All right, we'll see everybody before 8 o'clock in the morning. Thank you.
Okay.